Good afternoon, everybody, and welcome to another Tax Investigations webinar monthly special. Today, my name is Dave Jennings, and I'm joined by my colleague Dane Skiba. We are going to do an update on recent tax decisions at the tax tribunals and higher courts. For those who are watching on video or on YouTube, then welcome to that as well. So, without further ado, we will get into our session and start the slides. If you are live, you can ask questions. Just put your questions in the chat box and we will answer as many as possible at the end of this session, which will take around about 20 odd minutes to go through. So, as I've mentioned, brief introduction to ourselves. We are both ex-HMRC Inspector of Taxes. I've been in revenue a little bit longer than Dane. I'm a bit older in the tooth, and we've both worked at similar top 10 firms of accountants and specialists in the investigations dispute settlement arena. Churchill Tax Advisors, for those who are not familiar with us, we do provide full tax services. We work alongside other accountants for specialist services, such as some tax advisory and dispute investigations disclosures. We also work with solicitors, IFAs, and other intermediaries. We help their clients, or clients come to us direct as well. Always happy to have an initial consultation with people about their issues. So this month, as we mentioned, we are going to do an update on some recent tax cases, ones that we think you will find useful, and also keeping up to date with what's going on in the tax world at the courts. So we're covering a number of topics listed here: legitimate expectation, whether you can rely on an advisor or not, and does that give you any get out from HMRC or penalties? A couple of issues around discovery and revenues, opinion and valid inquiries. So the first case we want to do today is legitimate expectation. Now, this is an area that we have come across regularly and we have used with HMRC from time to time. Generally, the position is that any appeal or dispute on a particular matter has to follow law, legislation, precedents. You can't, in general, rely on, for instance, HMRC's published manuals, HMRC's leaflets, anything that's non-statutory. They don't form a specific defence before the courts. They may add weight, they may give guidance, they are obviously useful to understand an opinion, and they're useful in day-to-day work. But when it comes to the tax tribunal, those leaflets, guidance notes, do not carry the weight of law. Legitimate expectation, however, is sort of linked to that, but it's a slightly different technical matter. And what this means is, if, for instance, HMRC gave a specific view to somebody, or there is a point on a form, for instance, that someone followed, or you got clearance from the revenue. If you then followed that advice, guidance, comment by HMRC, for instance, then you may be able to argue there was a legitimate expectation that the actions you took followed what was normal and standard, and you could have relied on what the revenue have said. In this case, the appellant had made errors on some forms with regard to what suppliers were maybe liable to VAT or not. And they took the case to the first tier tribunal, who threw out the appeal and said that the tribunal had no was unable in its tribunal rules and laws and regulations to consider the point of legitimate expectation. It wasn't an angle of appeal that the tribunal were authorised to consider. So the client, the appellant, the taxpayer wasn't happy with that and appealed to the upper tribunal. So the upper tribunal considered this case, and they have said that actually the tribunal does have the right to consider legitimate expectation. It can consider if that is valid or not, and it can make a decision one way or the other. It does have, therefore, the right to consider legitimate expectation. So the client, taxpayer, appellant won on that ground. However, overall, they lost the appeal. The tribunal still said, yes, we can consider legitimate expectation. However, in this case, the forms had been completed incorrectly, and therefore the legitimate expectation was irrelevant in that they still filled out the forms wrongly. They hadn't correctly followed the rules and guidance with regard to the particular point. So it's a useful precedence to say that if you are unable to agree an appeal or an argument around legitimate expectation direct with HMRC, you can take that appeal to the tribunal. The upper tier is precedent setting on the lower tier, and therefore the first tier now does have the authority to consider legitimate expectation if that point is raised in appeals. So a useful precedent setting. Whether it's going to go higher up to the Court of Appeal, we don't know at this stage, but at the moment, the first tier can consider legitimate expectation as an appeal issue.
Thanks, Dave. This next case that we're going to look at is around whether having an advisor can amount to taking reasonable care, or how that affects HMRC's decision making when looking at penalties if they do find inaccuracies or the like. So in this case, Mr. Radis, who was the appellant, he was a UK resident but not domiciled in the UK. And in 15/16, I think he filed his, on his behalf, his accountant filed his 2015/16 return, the foreign pages incorrectly. HMRC subsequently opened an inquiry into that. It was established that the taxpayer had underpaid the remittance basis charge. A remittance basis charge is a charge that non-domiciled UK individuals can take advantage of to be taxed on only their UK income rather than their worldwide. But there are complexities around it, and it depends on the number of years in which they've been a UK resident, or the continuous years they've been in the UK about in the prior years, and the charge can change depending on that. HMRC, there was no dispute that there was an underpayment of tax made. The taxpayer accepted that, but HMRC then proceeded to issue a careless penalty under Schedule 24 Finance Act 2007, and that's the kind of the point that the taxpayer wanted to appeal on. The fact that he had an accountant on board who filed his return for him, who calculated the charge for him, showed that he was taking reasonable care and that no penalty should be charged. So they took it to the first tier tribunal, and that they did actually find that, yeah, in that case, having a professional advisor on board did amount to taking reasonable care. Given the complexities around it, it wouldn't be expected that an ordinary prudent person taking reasonable care would have been able to pick up some of those inaccuracies. With this, it gives a good steer that actually having an advisor on board can help, but it depends on the specific facts. If in this exact same situation, he didn't have an advisor, he couldn't be found to be taking reasonable care, and that penalty would have stood. But in different inaccuracies, having an advisor might not necessarily mean that that the penalty wouldn't be charged. It would have to be looked at on its own merits. But this one's a good example to show that that supported their view that reasonable care was taken.
Thank you, Dane. Yes, useful point to know, and there have been other cases in the past of penalties being reduced or taken away as reasonable care based on taking the advice of a professional. That could be any qualified professional or anyone that you rely on their advice as being accurate and correct. This is a An interesting case around discovery. There's been lots and lots of cases around discovery. So discovery is when HMRC are out of time to issue a standard assessment for arrears of tax, and therefore they're outside the inquiry window, and they have to rely on discovery rules in order to issue an assessment for prior year's tax liability. So the HMRC have to prove they've discovered something new that they didn't know, couldn't have been aware of at the time the tax returns were completed or the information was supplied. They found something new, they've discovered it, they've issued an assessment, and obviously taxpayers can then appeal, and it goes beyond that. A case we covered at a previous webinar, the one with Mr. Tooth. The issue in that was around whether discovery assessments could be deemed to be stale. That meant that if HMRC had the information for a long time before issuing a discovery assessment, the appeal in that case was that the revenue were now out of time to issue the discovery assessment because they'd had too long to consider the information. They should have issued the assessment earlier than they did. Before Tooth was decided in the Supreme Court that actually the principle of staleness doesn't apply, and the revenue have, as long as they're normal time limits, i.e. up to 6 years for careless, 20 years for deliberate, to issue a discovery assessment. The rule of thumb at other cases was around about 3 years. If the revenue hadn't issued a discovery assessment within 3 years, it could be deemed to be stale and therefore invalid. In this case, what's happened is staleness wasn't the point at issue. The point at issue was the fact that HMRC had discovered the same point twice, in that the taxpayer had not declared benefit in kind for a company car and fuel on the grounds that it was a pool car. It was a lead case alongside a number of other colleagues, presumably all probably sharing the same pool car maybe. The point of principle, the pool car issue, was never considered at the tribunal because this ended up being a point of technicality and had actually 2 tribunals. At the first tribunal, a week or 2 before the hearing, HMRC withdrew their assessments for the car benefits on a technicality. We don't really know what that technicality was, but it appeared to be purely around the specific wording and warning around the assessment. But they withdrew it and vacated those assessments, so the appeal hearing never took place. After that hearing, HMRC then issued fresh assessments in 2017 for the same issue. Again, the car benefits, tax had not been unpaid on grounds that HMRC had discovered this benefit in kind had not been declared, and therefore issued the assessments. The taxpayer appealed, and at this recent tribunal, the judge has decided that HMRC cannot discover twice. They only have one chance to discover. They can't withdraw assessments or vacate them, get rid of them, change their mind, and then reissue the assessments at a later date for the same amount, for the same issue that they discovered previously. So it's, again, a very useful point. It doesn't set precedent. It's the lowest tier. It may go to appeal. We don't know. The tribunal judge also gave very short shrift of HMRC's attempted argument to say, in actual fact, the other secondary view was the 2016 assessments were still in point, and therefore the appeal for those early assessments was just carried forward to the later assessments and had never been decided at the earlier time. The tribunal said that was a load of rubbish. HMRC had specifically vacated those assessments, which meant that they didn't exist. And therefore, if the assessments didn't exist, the original appeals equally could no longer exist. So you couldn't carry that forward to the 2017 discovery assessments, an attempt to argue that nothing had changed. They were just the same issue, just restated. That was incorrect. They were fresh assessments after the others had been withdrawn. and on those fresh assessments, they can't discover twice. Sounds like a title for a James Bond movie. So a useful point on discovery. Thank you.
Yeah, this one's to do with the validity of an inquiry, and really it highlights the importance of establishing the validity of an inquiry at the time in which it's issued, or if it's issued later or whatever. So this one is to do with Mr. Tinkler, and HMRC had supposedly issued a Section 9A inquiry into Mr. Tinkler's tax return for 2003, 2004. It was found after kind of 10 years of ongoing correspondence with between the agent and HMRC on behalf of Mr. Tinkler. It was found in the first tier tribunal in 2016 that the notice of inquiry had not been sent to Mr. Tinkler's usual or last known place of address or his place of business or employment, which is a requirement for valid notices in TMA 1970. So it was found that notice actually wasn't valid, and that's what Mr. Tinkler kind of was asserting, that although this had been going on for 10 years, the initial notice that was received wasn't valid. Mr. Tinkler's agent at the time, when back in around 2005, 2006, Mr. Tinkler's agent would have received a letter notifying them of the inquiry, and also they were provided with a copy of the notice that was sent to Mr. Tinkler, albeit at the wrong address. And the agent then proceeded to kind of communicate with HMRC and work through that inquiry, thinking it had been opened legitimately. The authority was in place for the agent, so they would have had a 64-8 form in place to kind of deal with HMRC on behalf of their client. But what it found in 2016 is that the lower courts found the inquiry notice to be invalid due to it being sent to the wrong address. Yeah. It was also found that having the 64-8 in place, which, although it gives them authority to deal with HMRC on behalf of their client, it doesn't give them authority to receive notices on behalf of their clients. So there's certain notices that HMRC have to send out to the taxpayer, this being one of them. So it was found that the agent didn't have that authority to receive those notices, and therefore the inquiry was invalid. However, HMRC appealed against the Court of Appeal's decision on estoppel, which is a legal principle that prevents someone from arguing something that contradicts what's previously been accepted or agreed. And the decision was overturned, and therefore the inquiry was found to be valid. So essentially, in the agent and the taxpayer kind of working through the inquiry for that period of time, it was deemed to be kind of accepted, even though technically the notice wasn't issued to the correct address at the time it was issued. So that was a win for HMRC in that one. So that just kind of emphasises the importance, really, to make sure that your inquiry notices are received in the correct way from HMRC, and it's was it received within the correct time that it was set out? Was it received to the correct address? Things like that. If it was picked up at the time, then the inquiry wouldn't have happened. HMRC would have had other powers to maybe look at assessing, but it wouldn't have gone on for the time that it did.
Thank you, Dane. I'm glad you also covered the meaning of estoppel, which obviously is a legal term, legal phrase.
It was a new one to me, actually. It's not something I've heard too often. No,
it is quite an uncommon point, but a very important principle of that case, which does crop up now and again from similar scenarios, and obviously Mr. Tinkler's appeal failed on the grounds that if you've been corresponding with the revenue on an inquiry, how can you then go back and say, well, I didn't even know about the inquiry when you've been corresponding about it. Obviously, it's a technicality. Some inquiries do fall over due to technicalities, and that can certainly happen. In the case of the Supreme Court of Howard versus HMRC, it's not exactly a technicality, but it's proved and shown that HMRC were incorrect in taking a view of tax avoidance. So it's quite a complex area, and it's not something that on its own we may see very regularly. It's to do with follower notices, where somebody has entered into a tax planning arrangement, which HMRC disagree with. They open an inquiry. If possible, they issue an APN notice, accelerated payment notice, so they can get the tax up front before the case goes to court and tribunal. Or they can issue a follower notice and say that actually a similar case has already been heard at the tribunal and HMRC won, and therefore we're going to say to you, your case follows that one, and you not only have to pay the tax up front, but equally, if you appeal and lose, you will be faced with an automatic penalty. In this case, the appellant said that the tax avoidance case referred to in the follower notices, which had already been heard in the courts and which HMRC had won, was not on all fours, was not sufficiently similar to the case of Howarth. The appellant was saying that their issue differed from the one that HMRC said it was the same. And ultimately, the Supreme Court agreed with the appellant, and they have made the point that for HMRC to show that an existing decision in their favour can be used in other cases, there has to be no scope for a reasonable person to have disagreed. Whereas the Court of Appeal had said that there just has to be a substantial degree of confidence in the opinion, which the HMRC had been relying on. So it does put a further hurdle and barrier and protection on taxpayers who've entered into arrangements that HMRC have to be able to show that if they're using a similar case, that it can be applied, and the reasonable person would judge them identical and be unable to disagree. They have to say that those cases are so similar in order to issue a follower notice. So it does demonstrate that Revenue's opinion isn't always right. These type of scenarios rely entirely on a view of a case. It's saying that case A, in our opinion, is identical to case B, and therefore you owe us the money. If you're going to appeal and you lose, you pay as a penalty. If you want to back down, you need to back down now to avoid all penalties. It's a bit of a bullying, threatening tactic. Obviously, it's used rightly and sometimes wrongly in tax avoidance inquiries and issues by HMRC. So a landmark case which will apply to all follower notices in the future, or some existing follower notices. HMRC have said they will review follower notices. People don't have to make appeals or notices to HMRC. They will go through them and notify taxpayers accordingly. Final case, Dane, thank you.
Thanks, Dave. So yeah, this one's really just to kind of talk about the importance of keeping records, which I'm sure we've mentioned many times before. But essentially, in this one, it was a case that HMRC picked up, and they looked into the income of Mr. Sharif in 2016, and in establishing that there was some inaccuracies there, they kind of raised assessments using their discovery provisions and the time limits under the failure to notify, which are a lot more generous for HMRC. And they ended up raising assessments going back, I think they did 16 years in total of assessments, and they were for £234,000. This was based purely on estimate and assumption, and because the taxpayer didn't have any records, HMRC were kind of left to try and kind of come up with their own figures, essentially, which is what they did, and which is what the 234 was based on. And all they really need to do when considering these assessments and when they have no records is make a reasonable estimate. So as long as they can justify the kind of the methodology as to how they get there, then that figure can be deemed to be reasonable. Obviously, the burden then falls on the taxpayer to kind of dispute that and without that evidence or those records, it becomes a lot more difficult to do. There were various sources of income in this one, and I think the taxpayer was successful in getting a couple of them down. I think there was a deposit for a house, for example, and the source of that deposit was assumed to be taxable in HMRC's estimates, and he was able to show that it came from some savings income, and that kind of dropped it down. But it ended up, I think the assessment was still in the region of £200,000. So a significant tax bill. So I think the key points to take away there is, obviously, if you've got records, it really helps in kind of defending yourself against HMRC. And when they have free rein to make what is a reasonable assessment, these numbers can get become quite excessive from what might actually be the reality. Again, as long as they can justify them. So if you've got the records, it helps to back that up. It also helps if you don't have the records, that actually kind of having some professional advice on board to kind of take control of that inquiry and make sure that the reasonable judgments HMRC are getting to can be countered. You know, we see this all the time. We end up putting what we think forward is reasonable, and it can be vastly different from HMRC's, but you can still get to a good agreement point on it.
Yes, thank you, Dane. And one of those areas is ADR, the Alternative Dispute Resolution, which we've had a very good success for clients in those disputes with HMRC. It's an avenue that can be taken instead of going to tribunal. So, in summary, from today's decisions that have been made in the tribunals and higher courts recently, HMRC isn't always right. We would always say that specialists should be engaged and considered for second opinions, or to look at matters, keep an eye where there's possibly a technicality around whether it's a valid assessment, a valid inquiry. There are always issues to look at, as well as actually the amounts that might be under dispute. So if you need advice, please contact me at Churchill Tax Advisors, or my colleague Dane at Churchill Tax Advisors. Let's see if we've got any questions from anybody. Happy to take questions now. We haven't had any questions on the cases so far. One item in news I've seen very recently is HMRC have started opening inquiries into unregulated advisors around allegations that they've assisted clients to commit tax fraud or evasion. Now, obviously, that's quite a serious allegation by HMRC, but obviously it's maybe indicative that HMRC are widening their scope of inquiries, and this isn't necessarily into accountants. It can be into estate agents, some electronic providers, solicitors as well. That if they've given advice, or if they've provided documents, or they've done some sort of assistance that results in a loss of tax, then those advisors are facing inquiry from HMRC. We know HMRC are clamping down on the promoters of tax avoidance, and this is another step in the way that they're dealing with these type of cases and inquiries. So it's not just taxpayers that face inquiries. It can be advisors and the like, and promoters who also face inquiries by HMRC. Do you have any other further points to make, Dane, from today?
No, thanks, Dave. No.
Brilliant, thank you. So thank you everyone for joining us today in this half-hour presentation of recent tax cases. Please join us again next month when we will cover a new topic. You will get an email update invite to the session, and if you are able to join us, as many have today, that'd be fantastic. Please watch the videos. You'll get a link to the videos as well again each month. And in a couple of weeks' time, please join our colleagues who will be giving a presentation around a tax planning or tax advisory subject. Look forward to seeing you again soon. Take care, everyone. Thank you. Bye-bye.
Thank you. Cheers.